Abraham Lincoln warned that the philosophy of the schoolroom in one generation will be the philosophy of government in the next. Would you like to know what's being taught in today's classrooms? Welcome to Say What? With attorney Mark Schneider and Pastor Gheorghe Rosca Jr. They'll explore the issues facing children, parents, and society as a result of the public schools and the forces behind them. Say What is the radio program of Protect Our Kids, which seeks to inform and equip concerned citizens about the looming crisis in American education. So listen in as your hosts, Mark Schneider and Gheorghe Rosca Jr., unpack the issues and organizations affecting our children. And now here's your hosts, Mark Schneider and Gheorghe Rosca Jr.
Hello, everyone. I'm Gheorghe Rosca.
And I'm Mark Schneider.
And we want to welcome you to today's episode 170 of Say What, where we talk about the threats to our children in the public school system, including a recent lawsuit that was filed against the governor of California and other state officials that challenges the constitutionality of the most recent attack on children and parental rights.
That's right, George. This case is entitled Chino Valley Unified School District et al. Versus Newsom, meaning the governor of California, Gavin Newsom. And this is a case that you know something about since you're a named plaintiff in the case as an individual, not acting on behalf of Protect Our Kids. Nevertheless, we're actually very welcome that you're a plaintiff in the case. And we're going to go into some of the history of the case. It was filed recently on July 16th in the federal district court. So this raises federal questions, hence the reason it's in the federal district court. The plaintiffs, as I mentioned, are Chino Valley Unified School District, which is in Southern California, along with a number of named individuals who are parents of children across the state of California. Who have kids in the public school system, and also who are in schools that have what you and I have talked about many times on this program, parental notification policies. And we're going to get into more of what exactly that means. The defendants in the case, as I mentioned, is the governor of California, Gavin Newsom, but also the state's attorney general, Rob Bonta, and the California Superintendent of Public Schools, Tony Thurmond. So, George, this case is actually, or the bill behind the case, Assembly Bill 1955. The names they give these bills are, they're never surprising, but they should be. This bill is called the Safety Act. Can you tell us more about what this bill entails?
It really reminds me of like the California Healthy Youth Act, right? That just mandated comprehensive sexuality education. These people are really good at naming their bills.
They have a particular talent for it.
So the Safety Act basically, Mark, goes into effect at the beginning of next year, so January 2025. And it's really an act that was brought about by another individual that's not named on the lawsuit, but this is the author of the bill, State Senator Scott Wiener.
Yes.
I think we all know his history, his ideology, and for some reason, he's just locked onto making parents' lives miserable because there's a clash of worldviews, obviously, that's going on between his LGBTQ or his queer theory ideology and what he thinks about, parent rights versus children's rights.
Yeah, just for our audience, Senator Scott Wiener, he's the head of the LGBTQ caucus that he brags about in the assembly. And this is a group of 12 or 13 members, I think. Yeah. So it's a very strong group of people. And they have been almost singularly responsible, George, for constructing and then passing some of the most destructive bills for parents of children in the public school system, not to mention the children themselves, sexualizing children, taking away parental rights. So that's who we're dealing with here.
Exactly. And so the Safety Act, quote unquote, it'll prohibit school officials now and outside contractors from notifying parents about some really important things about their children, while at school.
So it basically allows for social transitioning without parental notification
a child can basically, regardless of their age now, and this is the other scary part, we've always dealt with in California the whole Medical Privacy Act that says children 12 and above now have certain privacy rights. For example, they can go and see a medical practitioner, and that conversation between them remains between them. Parents just will get a bill, regardless of what they're being, advised or not. But now for this, there is no age. Your child could be in kindergarten, could be in second grade, and whatever conversation happens between them and any school official, all of a sudden can be kept secret and hidden from parents.
And the particular conversation that we're talking about is when a child decides to identify with a non-natal sex. So, in other words, George, they're sort of coming out and they're telling someone, letting somebody know. And in these schools that have parental notification policies, when a 5 or 6 year old all of a sudden starts identifying because it's cool with a non-biological sex, the school officials are obligated to tell the parents. This would preclude that. It would prevent them from doing that.
Not just that, but the law states specifically that all of these school districts that have gone around and placed parental notification policies, that those are illegal now. And in fact, that's what triggered this law, because Tony Thurmond actually came down to the school board meeting of the very first school board that passed a parental notification policy. He was basically shown the door, and this was in Chino Valley.
We remember this well.
Yeah, and it's on YouTube for folks who want to watch, how well he was treated there. But he came down, he spoke out against it. The Chino Valley School Board ended up passing it. Other school boards across the country took that model policy and adopted it, seeing that they don't stand a chance in red or purple counties. Now they develop this strategy, which goes completely against their own political theories of local control. Politics is always, pushed down to the lowest possible rung on the ladder, because there is, I think, this philosophy of politics in the United States that the best decisions are made as close as possible to that community. And so when we're talking about school boards, those have always been very influenced by just the local school district. And obviously there's state laws and ed codes that govern everything. But I think we've all realized, and throughout history we've realized, that there are unique things that happen in every school district that parents in that school district that have elected their, fair representation on the school board, that those people can make the best decisions. And so sure enough, they're going against that thought as well.
Yeah, you mentioned local control, and there's a Catholic concept. It's called subsidiarity, and it stands for the proposition that the best decisions when it comes to politics and the way we self-govern ourselves as a democratic people are made at the most local level. And increasingly what we're seeing from our state legislature, not just California, but across the country, is that state officials and even federal officials are taking local decisions out of the hands of parents and interested people and assuming this authority themselves. And we should also say, George, that as you mentioned, this lawsuit really, or the bill, AB 1955, was a response to parents getting together collectively and going to their local school boards and complaining about what were increasingly called parental exclusion policies. So these were school boards that were passing in secret policies that govern the entire district, requiring that school officials remain silent about what's happening to parents' children in the school. In fact, they would even go so far as to have a double book system. So one set of books with the child's natal sex on it, and a completely new set of books with the child's preferred gender identity and pronouns. So parents became upset about this, went to school boards and said, we need to fix this problem. And hence they started passing these parental notification policies. And I think, George, don't they exist in around 7 different school districts around the state?
Yeah.
Somewhere around there. So the irony here, George, and maybe you can talk a little bit about this, is that when a child makes a gender identification known at a school, aren't they sort of already going public with this information?
They are. They've basically just outed themselves. They've come out of the closet, so to speak. And the narrative that Senator Scott Wiener wants to push is that, well, there's a reason why they are only comfortable to come out at school. And the narrative basically paints parents as, the oppressors, that if these kids in any way, shape, or form are going to come out to their family, that they would be kicked out of their house, that they'd be going and sleeping in a homeless shelter or in a halfway home. And over they paint that kind of a picture to basically, I guess, maybe look for empathy for their LGBTQ community. But what's interesting is that, with all of that, there's these claims that, their mental health will be affected. And yet we already know that that's not really what's happening.
We're going to talk about the mental health aspect in just a second here, but just to be clear on this bill, AB 1955, makes the worst assumptions about parents. Yep. They view parents as sort of an evil interloper in a child's personal life, to the extent that they're excluding them for knowing about their own child's most intimate temperaments and aspects of their lives. So I guess it behooves the question, when children are bullied, when they're discriminated against, if they threaten self-harm, even if it's a minor injury at the school districts are required to notify parents of this. Why the exception for gender identity?
To me, it's strictly political and ideological. So they really want to have these kind of policies in place with these kinds of exceptions. I don't know. I've tried to think, like, who gets the benefit from all of this, right? And I think in Scott Wiener's mind, given his own upbringing and probably, in the 80s and 90s, when he was, growing up and having to, come out, the social acceptance might not have been there, right? As a society, we were nowhere close to the kind of social acceptance we offer today. And so I think he thinks that this is the most healthy thing that we could do for the kids. And this is the way we keep them safe, hence even the name. But we've already been down that road. We, as in, I mean, just humanity in general, like in Sweden, they've offered their society the highest degree of acceptance, and yet people are doing much worse by going down the path, of LGBTQ. So I think that there might be some, honest desires on their part to keep kids safe from maybe a very, very, very minute, exception of parents who might go ballistic when they hear this stuff. But that pales in comparison to what actually happens to kids who end up going down this road with all of the social acceptance and support that they will ever ask and want. They still fare far worse.
Yeah, we're talking about a life-altering decision here that the school is grooming and promoting. And, of course, one of the tropes that you hear continually when it comes to this issue is that we need to do this for psychological and medical reasons, for the medical well-being of the child. And as you mentioned, George, Sweden, in fact, a lot of the Northern European countries, they have a long history that far precede what's happened in the United States, promoting LGBT rights and transgender ideology. And despite the welcome culture that exists there, even for post-transitioners in these very welcoming societies, the suicide rate is 19 times the general population. And this has been verified in study after study. In fact, George, maybe you can talk about a little bit about what the medical community has found with respect to a lot of these children who are identifying with a non-natal sex, including comorbidities.
Yeah, so we're now probably going to be referencing a term out there in the industry called gender affirming care. That's the, fluffy fairy tale end of the story. Again, they like to use very nice words, right? So gender affirming care is that as soon as a child thinks that they are someone else or something else for that matter, because that's happening as well. We're seeing kids in schools identifying as furries, which is really, really shocking. But gender affirming care basically says that as soon as a child thinks they are someone else, that the best evidence out there medically is to go along with their dream. Okay. And that if you do that, they will remain alive. And parents are constantly harassed with the notion of, do you want, a daughter that's alive or a son that is dead? And that's what doctors are constantly putting in front of them.
Yeah, so they paint it in pretty stark terms.
Very stark terms. So now parents have this decision to make, like, okay, I need to support, I need to affirm, I need to be positive about this, regardless of the fact that actually all of the evidence paints a whole different picture.
Isn't it true also that a lot of these kids come with emotional or mental health baggage even before they decide to come out? This has been proven that they're called comorbidities. Bipolar, previous mental health issues, depression, things like that seem to be part and parcel of kids who tend to identify with the opposite sex, or no sex.
Yeah, or no. Yeah, I think comorbidities is a huge one. The other thing we learned from Abigail Schreier's work is that it's just a social contagion that tends to affect in a very disproportionate way girls instead of boys. Yeah. Whereas historically gender dysphoria in a very disproportionate way affected boys, not girls. So there are these huge swings in the data sets of who's going through this and for what reasons. And so the spectrum is probably the biggest reason on the comorbidity side, and just social contagion on why girls are predominantly going through this.
You talked about the autistic spectrum,
yes,
where you fall on that, and that's a very wide range.
Yes.
The schools use this term social transitioning. They want to enable the child to transition socially, but this becomes sort of a perpetuating thing, right? Yeah. The more social transitioning there is, the more kids they don't want to be left out, and if they're at all on the border from peer pressure, this is going to make it easier for them to take the next step and say, oh, well, I'm also trans. And so the schools are going to start promoting this. George, part of the complaint mentions this organization called WPATH. This is the World Professional Association for Transgender Health. And this is an organization that has traditionally existed for the sole benefit of promoting transgenderism. But as the complaint points out, maybe you can talk a little bit about this, most of the publications that have come out of that organization and public statements have wanted parents to be involved in these life-changing decisions. Isn't that true?
Yeah, and in fact, they state things like, children lack skills for future thinking. They lack the planning ability. They lack the ability to see the big picture. And I think every parent just knows that, either from, looking back at their own experience as a child and the dumb decisions they've made, to now dealing with their own children and just saying that, look, there is something that we've known for as long as human beings have been around, that there is a developmental stage biologically that happens. I think insurance companies have actually kind of codified a lot of that into their own policies. Why is it that, kids getting an auto, insurance policy are charged a lot more than a person over 25, right?
That's right.
So these things we've known for so long, and our society has adjusted its way of functioning around all of these truths. And yet all of a sudden, just because, a Senator Scott Wiener claims that those disproportionately affect the, LGBTQ community, now we go away with all of, the thousands of years of accumulated, human wisdom.
In fact, the complaint says, and I'll quote from the complaint, plaintiffs are not aware of any professional body that has endorsed school-facilitated social transitions without parental knowledge. So this playbook, George, of parental exclusion promoters is the same as child predators, according to Abigail Schreier. And, of course, she's famous for writing her book, Irreversible Damage, which you've mentioned. This is what she states. This is sort of the strategy. You target the victim, gain their trust, fill a need, and crucially isolate the child from her parent. For several years, this has also been the standard California state protocol with regard to school children questioning their gender identities. George, even Elon Musk tweeted recently, he called this law, AB 1955, the final straw for families and announced his intention to move both SpaceX and Tesla, two of California's most important companies, out of the state as a result. He made the statement, the goal, talking about AB 1955, of this diabolical law is to break the parent-child relationship and put the state in charge of your children. Is he wrong?
He's spot on. And I'm so grateful that Elon has been tweeting kind of nonstop ever since the law passed and the lawsuit was filed. I think he's probably been the greatest supporter, of the work we're doing to fight against it. But, Mark, one other thing that I think Abigail Schreier pointed out is that this law basically prevents parents from being able to get organized and fight against whatever's going on at the school district level because they're kept in the dark. They will not have a clue of what's going on. And so talk about taking away our ability to be able to, again, be involved in a local governing body. That won't happen anymore.
Ergo the lawsuit.
Yeah.
This is clearly unconstitutional. And we should probably talk about the causes of action that the complaint raises and how we think this may be played out in the courts. So there are three causes of action, and then at the end, the complaint is actually asking for a declaratory judgment for the court to announce that AB 1955 is unconstitutional, it's illegal, and asking for an injunction on the law. So the first violation that the complaint cites is around what's called substantive due process, and this has to do with the 14th Amendment. Of course, the 14th Amendment protects people against lack of legal process in violating their rights. And substantive due process stands for the proposition that some things are so basic to human freedom, to American liberty, they're deemed fundamental rights. And of course, one of those things, George, is parental rights, the right of parents to control the upbringing of their children. Well, Assembly Bill 1955 completely violates this. And there's a long list of cases that substantiates this fundamental rights to parents to control the upbringing of their children. Going back to 1923, Meyer versus Nebraska, 1925, Pierce v. Society of Sisters, more recently, Wisconsin v. Yoder in 1972, and finally Troxel versus Granville in 2000. And there are many more cases as well, all to say that a state cannot infringe a parent's fundamental right to control the upbringing of their children without due process of law, which is exactly what this bill tries to do.
And Mark, can you also explain, because you mentioned right at the beginning something about injunction. What does that mean?
So an injunction really, it's where the court steps in and orders whatever the damage being done by what's being complained against stops. It's halted. And this usually happens, there's various levels of injunctions. There's temporary injunctions, preliminary injunctions before a trial is actually held on the merits, and then permanent injunctions. So what probably is going to happen if you have a sympathetic court is that they will issue either a temporary or preliminary injunction until there's a full trial. And then depending on the results of the full trial, that will result in either AB 1955 ruled constitutional and it'll be enforced until it's appealed at the Ninth Circuit, or there will be a permanent injunction in place saying, yep, no, this law cannot stand constitutionally. So the next violation that the complaint raises is on the First Amendment's free exercise clause. So, George, you are a believing Christian, and you have certain religious views that comport with that belief system. And one of those beliefs is that children, human beings, come in only two sexes, male and female. Can you talk about that a little bit?
Yeah, I mean, it's, for me as a believer, we believe in what the Bible says. Children are created in the image of God. All of us, every human being is created in the Imago Dei, and God made them male and female from the beginning. And it's not rocket science. I think for as long as people have been around and documented history, human beings have viewed themselves as either male or female. And this recent phenomenon of, mental craziness is, beyond me why people would go away from such a known fact of science. And so I also see that my beliefs are actually in line with what science says and with what biology says and what we've known all along.
Yeah, I mean, of course, the counter to that, and the defense will raise this, is that, we have separation of church and state, and you can't impose your religious values on your children in the public school system. And so this will certainly be tested. But the First Amendment and the Free Exercise Clause, freedom of religion, goes back to the founding of our country. It was first delineated in the Declaration of Independence. It's first among equals in our Bill of Rights and the Constitution. So this will be very interesting to see how this plays out. Moreover, George, isn't the school putting forth a kind of cultic religion themselves when they are insisting that human beings can be whatever sex that they want to? This is not based on any scientific premise.
Yeah.
No empirical evidence to support that.
This is Scott Wiener believing something.
Passionately
and putting it into his own law and getting that law passed. And so now he's trying to enforce his own belief system on me.
And then finally, George, the complaint states that AB 1955 is a violation of the Family Educational and Privacy Act. This is known as FERPA. This is a federal statute that was passed in 1974 that basically says that parents have a right to see their child's school records. Not only see those school records, but if there's an error in those school records, to protect them. So AB 1955 goes completely against FERPA, does it not?
It does. It takes away my ability to be able to see my child's records and records that have been unaltered. I don't want to see the double book, when I ask for my child's information. And I want to see exactly what he's going through. I want to know if they gave him any kind of medication. How else could I help him at home if they do something at school and at home I come and I do something that will, Lord forbid if they, especially some of these kids that are going on puberty blockers, right? And their parent at home will give them some kind of medication that has an adverse effect when combined with whatever the child was just given at school. You can kill your own child doing that. How would a parent know? We need to know the truth.
We do indeed, and we're going to have to wrap it up pretty soon here, George. We are so happy that you are a named plaintiff in this case. You're a founding member of Protect Our Kids, so this is obviously something that we're going to be following very, very closely in the months and years ahead. We believe as an organization that AB 1955 presents a frontal assault against the nuclear family and against parental rights, not to mention our innocent children. It sends a message to children that leading a double life is acceptable and to distrust their parents. It eliminates the ability of citizens, as you mentioned, George, to self-organize and influence local school board policies. And it mandates state authority over a child's gender identity with all its concomitant consequences. All terrible things, George.
And Mark, just, trying to maybe say it in a different way to people out there listening, the Constitution has never granted the state parental rights. And so think about it that way. If you're a parent, you as a parent you're the only one that has parental rights. And a lot of times I say statements like, I don't co-parent with the government. And I don't, because the Constitution has never granted that right to the state. That's mine. And the state is consistently pushing that envelope. And here they've went way deep into this, where they are behaving as the parent of my child.
It's truly Orwellian, but the fact that this case has been mounted, and there are others similarly that we expect to be mounted fairly soon in other states that have similar kinds of policies. So this is going to be very exciting to watch. And if there's any encouragement, it's that citizens are finally, like you, George, finally standing up to these assaults on your constitutional rights, not to mention your children. Well, that's all the time that we have for today, but we look forward to seeing you next time in a discussion about what's going on in the school system on our program, Say What?
You've been listening to Say What, the radio ministry of Protect Our Kids, where they seek to inform and equip concerned citizens about the crisis in American public education and the forces working against our children. Join us at this same time every Saturday as attorney Mark Schneider and Pastor Gheorghe Rosca Jr. unpack the issues so that we can better safeguard our nation's children. And join Mark and George right here next week at this same time for another episode of Say What.